a threat? What sort of disputes could arise that could go to these binding courts or binding tribunals, panels? Well, one area that's clearly covered by the treaty is pollution. One would think that could be reasonable and necessary and natural with regard to pollution in the open ocean. This is a law of the sea treaty, after all. But it also applies to pollution from land-based sources, and that comes as a great surprise to most people when they find that out. But that's why it's useful to read the treaty, because when you read the treaty, you actually find out some of these things. Article 213 of the treaty is entitled, very frankly, very simply, very directly, Enforcement with respect to pollution from land-based sources. And that article says states shall enforce their laws and regulations in accordance with Article 207. That's fair enough. We pass our laws. We should enforce them. And shall adopt laws and regulations and take other measures necessary to implement international rules and standards to prevent, reduce, and control pollution of the marine environment from land-based sources. Well, wait a minute. I thought Congress and other political bodies in the United States determine our domestic laws, including about pollution from land-based sources. This is a distinct departure from that. This is a mandate in an international treaty saying we shall adopt other laws to enforce international notions, international standards about pollution. Another applicable article here is Article 207, and under 207.1, it again says states shall adopt laws and regulations to prevent, reduce, and control pollution of the marine environment from land-based sources, taking into account internationally agreed rules, standards, and recommended practices and procedures. Once again, my reaction when I read that is, wait a minute, I thought Congress was in charge of environmental policy in the U.S. I thought state legislatures were appropriate or in charge of that policy. Bodies elected by the people. Isn't that what democracy is about? Well, this is a distinct departure. This is internationalizing many of those issues with mandates in the law of the sea treaty that we go beyond what we may think is the best law in these areas and that we conform to certain international decisions. And again, the title of the article couldn't be clear: enforcement with respect to pollution from land-based sources. Again, this is just one example of an issue area where the U.S. could well be ceding autonomy, ceding authority to other folks outside our borders who don't necessarily have our values, our notions, our best interests in mind. Now, what sort of situation could arise from this? Well, I think the situation that would undoubtedly arise is an outbreak of international lawyering and litigation, trying to move decisions that are presently before elected political bodies in the United States to the international arena. Many folks who have studied this phenomenon call it lawfare. Again, not warfare, but using international law to oppose us and battle our interests and move those decisions from the domestic political environment to an international tribunal, an international stage that very often doesn't have our best interests in mind. And again, U.S. autonomy gives way to international litigation. This isn't a wild conjecture on my part. This isn't something I'm imagining or seeing in the future. This is something that many international lawyers and activists are actively licking their lips over and looking forward to. In fact, there was a law review article published several months ago that was very straightforward about this phenomenon that would occur if we become a party to the treaty. And the author of this law review article said very clearly, quote, climate change litigation, one example of environmental issues, environmental litigation, in national and international fora is emerging as an alternative means by which to hold states and private actors accountable for climate change damages. The United Nations Convention on the Law of the Sea is a promising instrument through which such action might be taken, given its broad definition of pollution to the marine environment and the dispute resolution mechanisms contained within its provisions. Exactly what I'm talking about. That policy, that issue now is subject to our determination in Congress, is subject to the activity of other elected bodies in the United States. But under the Law of the Sea Treaty, it would be moved to an international forum, to international litigation, to lawfare, in many cases, against the values and interests of the United States. Now, we have great disagreement and debate in this body about significant issues like climate change. And that's legitimate in a democracy, and we should have those debates, and we should hash out those differences, and we should make the best determinations and policies we can on behalf of the American people. But that's something very different from pushing those issues and those decisions outside of the United States to international courts, to international tribunals over which we essentially have no control. There are other issue areas that could be the subject of this sort of international litigation, other countries hauling us into court to oppose our values and interests. Another topic where this could happen, and this gives me grave concern, has to do with military activities. And I actively asked many of the expert witnesses in our hearings before the Senate Foreign Relations